PLS 201, Legal Research and Writing for Paralegals, Week 7, Legal Memoranda, and Legal Briefs. Legal Memoranda. An office memoranda may provide information about a case or matter. A office memorandum, a legal memorandum, will provide information, either legal or factual-based information about a case or matter. When writing a legal memo, remain neutral and stay objective. Avoid using phrases such as "I believe" or "I feel," because the task is to provide information from authorities, not to state one's personal opinion. Be specific and reference additional research if it is present in your legal memorandum. Be complete by analyzing the case and applying them to the facts of the client's case. By that, we want to look for some similarities between the cases that have been used in our legal research and our client's case. This will make the case law that has been used that much more effective in the drafting of the legal memorandum. A legal memorandum consists of the following parts, and please remember to have this list with you when you draft your first legal memorandum. A legal memorandum should have a heading that identifies the document. The legal memorandum should identify the legal issue or legal question being presented in the document. A legal memorandum should provide a brief answer to those legal issues being presented in said legal memorandum. A legal memorandum should include a statement of the facts to present the client's story. A legal memorandum should include the statutes as applicable, analysis, and discussion using a thesis statement to guide in the case analysis. Do not merely summarize the cases. Critical case analysis is important in a legal memorandum. Critical analysis is key. And a legal memorandum will include a conclusion, which will provide a brief highlight of the analysis of the issue, the case law, the statutes as applicable to the legal issue, and therefore bring us to a rightful legal conclusion. Thank you. PLS201, Legal Research and Writing, Week 7, Part 2, Legal Briefs. A legal brief is a persuasive, formal, written legal argument submitted to a court. There are 5 tips for effective legal brief writing. Those tips are as follows. 1. Be persuasive. 2. Be concise. Do not add unnecessary information. 3. Use a thesis or guiding statement. 4. Be honest. Be ethical. Doing so increases your credibility. Doing so increases your chances of success. 5. Follow the court's rules regarding the format of a brief. Legal briefs. Trial court briefs are submitted to the trial court judge and are meant to persuade the judge in favor of the client. Trial court briefs need a brief introduction, so be specific in your introduction. Include all of the following elements in the trial court brief. 1. The caption, which identifies the pertinent information about the case, an introductory statement, an accurate statement of the facts that is as favorable to the client as possible, the argument, which consists of the analysis of the legal authorities that supports the client's case, the conclusion, which is a brief highlight of the argument with a signature block and date prepared, certificates of service and compliance showing all parties received a copy of the pleading, and any exhibits for the court to review. Appellant briefs. Appellate briefs include a cover sheet identifying information for the parties. If a party is to lose a trial, or, unfortunately, a motion, they may wish to file an appeal, and that is what an appellate brief will do. So once we have a cover sheet, we want to create a table of contents showing the reader where to find each element in the brief. We want to include a table of authorities that lists every primary and secondary source with page numbers, as well as complete citations of those sources using the Blue Book or the ALWD. A jurisdictional statement and reference to the pertinent authority, constitutional and statutory provisions along with the proper citations using the Blue Book or ALWD. Appellate briefs should include a presentation of the issues or questions needing review, a statement of the case with a brief overview of the case's procedural history, a statement of all facts that have already been proven at trial and their reference location, a summary of the argument, which is a narrative summary of the argument presented below, the argument or analysis of the authorities convincing the judge, the appellate judge, to rule in favor of your client, a conclusion specifying the relief sought, a signature block with a date followed by certificates of service, and make sure you are in compliance, and finally, an appendix.